And I want to echo what Michael was saying, that this is, I do this presentation probably 4 or 5 times a month at different brokerages, and this is a very, you can tell this is a very family-oriented, very just, you guys have great energy, so I just wanted to echo that as well. And so, my name is Justin Stivers. I am an attorney, and I own the Probate Law Firm. It's a law firm. We just moved into Brickell, but we're operating in about 16 different counties across the state of Florida. And we do one thing only, probate. So I don't do title, I don't do real estate. I deal specifically just with probate. And so I started doing this presentation because I've noticed that probate is something that a lot of realtors are not too familiar with, but it's something, especially in Florida, especially here in South Florida, that is coming up a lot more often. And so, my goal for this presentation, try to get you guys out of here and then, by 11. But the goal of this presentation is just to give you enough information so that if you can identify when a property might go through probate, then give you enough information so that you can use just some of the key words, key definitions, so that when you go to a listing presentation for a probate property, you can know more than other realtors and really stand out from your competition. And then just lastly, give you a couple ideas of how to market for probate listings, because at the end of the day, it's about listings. And also I want to say I'm always glad to be on the Key. My wife's grandparents have lived on the Key for 30, 40 plus years, and we were the second to last wedding at the old yacht club before they tore it down. So always glad to be here. I normally like to go around the room and get everyone's name, how long they've been a realtor, and some other information. But it's awesome, great group. So I'm not going to do that to take too much time. But just to kind of gauge the room, how many brand new realtors, just by show of hands, less than a year? Anybody? Okay, yeah. welcome. How many 5 years of experience or more? Or more, yeah, 5 years or more. Keep them up if 10 years or more, 15 or more, 20 or more. All right, so we'll stop there. We'll stop there. All right, so we've got. Yeah, I know there was. I don't want to point anyone out, but we got a very experienced group, a couple newer realtors. So welcome. It's an exciting career. How many of you all, show of hands, have dealt with probate in any capacity, either as a realtor or personal? Okay, so fair amount. Anyone want to say good, bad experience?
Great experience.
Great experience? Okay.
Yes.
Difficult experience? Okay. Took a long time?
Yeah. Yes.
Yeah, okay. So that's one of the things I hear a lot. So I think, probate is definitely, it can be challenging, and there's a lot of things that happen that are outside of our control that can make it frustrating, but I do think it's a market that there's a lot of opportunity there, because there's not a lot of realtors who quote unquote specialize in probate. I know there's a certification you can get now, and some realtors are doing that, but it's not something that I come across a lot of realtors who are extremely knowledgeable. And I think if you kind of learn enough, educate yourself, hold yourself out kind of as a probate expert, I think there's a lot of potential to get listings there. So, all right, so with that being said, and if at any point you guys have questions, please just shout them out. Yes, ma'am.
Do you deal with probate issues when there are international assets?
Well, if they're international assets, they're normally done in that home country. Yeah. But good question. Okay, so just to start, so when you all, someone calls you and says, hey, I've got a listing, what's the first thing you all do? Anybody? Tax roll, right? You guys, for the newer realtors, that's what you should do. You want to go find out who the owner is, and make sure you're speaking with the right person. So I have a couple examples here, and we'll point to the first one. So there was 4 handouts. Did everyone have? I don't know if we ran out or not, but everyone should have 4 separate handouts. So let's take a look at the first one, and this is how to identify a property that might go through probate. That's the first kind of session we're gonna chat about. So let's look at the property address, 11309 Southwest 200th Street. Let's pull that out. And actually, before I even get into that, but we can have that one ready. Let me just explain some of the key definitions, key words, so that you guys kind of have a working knowledge of it. So probate in general, what is probate? The way I like to explain probate is it's a court process. Okay, there's judges involved, there's attorneys involved. It's a legal process after someone has died, so someone has passed away, and you're taking what that person had while what they have, and now you're distributing it to their beneficiaries, to their heirs. So in your all's world, in real estate, it's taking a property that was owned by someone, he or she has passed away, and now you're going through the court process, and at the end of the court, you're going to get a new deed that says who the new owner is. So that's what probate. So whenever you think probate, just think, someone's passed away, there's courts, there's attorneys, there's judges. That's kind of what probate is. And there's a wait. And we'll get into, I'll address how long it takes and all of that as well. Another key term, decedent. That's just a legal term for the name of someone who's passed away, essentially a dead person. Decedent is what we call someone who's passed away. An estate, so again, another common term you'll use. An estate is basically all of the things, assets, properties, money, jewelry, heirlooms, whatever, that a person has, what they had, and now that they've passed away, we refer to all of that stuff as their estate. So John Smith, he owned his house, he owned everything, his car, all of that. Now we just call all of that stuff his estate. It's all a part of his estate. Last will and testament, who knows what a will is? Okay, what is it? Yeah, pretty good answer. Yeah, so basically a will, last will and testament, it's a piece of paper, a legal document that basically says, when I die, I want this person to receive this. I want this person to receive this. Very simple. And then personal representative, and I put on here personal representative / executor. They mean the same thing. Sometimes, for example, New York uses the word executor, Florida uses the personal representative. This is very important for you all because if you're listing a property, you need to be working with the personal representative. And we'll get into who the personal representative and all of that is. But the personal representative is the person who has the authority to sell the property. Okay? Does that make sense? So just kind of running through those, but those are some key definitions. All right, so if I'm speaking fast, just tell me slow. Y también hablo español, pero okay, so the property that I referenced a second ago, 11309, the owner, if you look under that, the owner is Maria Pichardo, Est Up. Estate of Maria Pichardo. So this is probably one of the easiest ways that you'll know if a property needs to go through probate. So if someone gives you this listing, you go onto the tax roll, property appraiser's website, and you see EST of after somebody's names, about 99% of the time means it's got to go through probate. Means that, so this is one we did, so Maria's daughter came to us. She couldn't sell the property until we did a probate and changed title. So a lot of times, if you see this, you're excited. You're like, hey, let's list this. Let's get going on it. But if you see EST of, you're gonna waste a lot of time. You're gonna go to the title agent and the title company, title attorney, or whoever, and they're gonna say, no, we can't sell this. You can't sell it until you go through probate. So this is probably the most common way if you're evaluating a property, if you see EST of, to know whether or not it's going to go through probate.
So she doesn't have a will.
She did not have a will. She didn't have a will, and we'll get into wills, but a will does not avoid probate.
Really?
So yeah, and we'll get into that. But that's a common misconception. A will will not avoid.
You have to be on title in order to.
Yeah.
The daughter would have. Yeah.
Hold that for like 2 seconds, and
Sure,
we'll get
sure,
to it. Yeah, but she didn't have a will, and so it had to go through probate. Okay, so that's the most common one. All right, let's look at now 1821 Northwest 33rd Street. Okay, so this one is, there's two owners on there. So you see Jesus Silva, EST of, and Maida Silva. So this was an interesting one. So Jesus and Maida, Jesus is the father, Maida is the daughter. They own the property 50-50. And without getting too much into title, they owned it as what's called tenants in common, meaning that Jesus owned 50%, Maida owned 50%. Well, Maida was the only child. She was already on title. She thought she could sell the property, so she gets a realtor. The realtor, they spend 4 or 5 months marketing the property. They go to closing, and the title agent says, no, you can't sell. You need to do a probate for Jesus. And so she was obviously frustrated. We ultimately did the probate, got the property 100% in her name, and then she was able to sell it. But you can imagine she was kind of pissed off. Rightfully so, I would say.
But that one would, if it was joint, with the right of
Right. Yeah, exactly. So there are ways to avoid probate, and I'm going to touch on that on the next one. But this one specifically, she wasn't. It wasn't able to avoid probate, and so this is really common, especially here in Miami. You see a lot of times where siblings maybe own a piece of property together, or the parents deeded part of the property to the children so that they own 50%, 25%, or however so, and they think. They just don't know. Well, I'm the only daughter. I'm the only son. I automatically get the property. They go to the wherever they go with the death certificate and their driver's license, and they think they're going to get property. So if you see this, this should bells, whistles should start going off in your head. Yes, ma'am.
How long did the process take for that particular case?
This one only took about 2 months. 2 months, yeah. This one only took about 2 months. That's and I'll touch on. Yeah, but the frustrating part was they wasted 4 or 5 months, listing it. So that was I'm sure she didn't want to go through probate either.
Did it only take 2 months because you're so good at it?
Yes. Yes. No, there's each situation is a little bit different, and I'll touch on time as well. Towards the end, I'll tell you what makes some go faster, what makes some go slower. Really, just briefly, it's because he had died a long time ago, which kind of sped up the process.
And what about if she had siblings? Would the process? No.
It wouldn't. Unless she had a sibling who didn't want to sell it or something like that, who was fighting her. But no, this one, it was pretty. That wouldn't really affect it too much. Okay, so how could they? Some of you guys have been hitting it on the head. If they had owned it with joint tenants, right of survivorship. Let's look at the last one I gave you, 13926 Southwest 161st Court. Okay, so you see on here, Karen S. Rodman, TRS, and then under that, Karen Rodman, in parentheses, BEN. So what that means is this property is owned by a trust. Okay, this property is owned by the Karen S. Rodman Trust, and she has named herself. I'm actually not sure who the beneficiary is, but she's named another beneficiary for this. A trust is, I don't want to I always get a lot of questions about trust. That's a whole, another topic. But trusts are a useful way to avoid probate. So if you have a piece of property and you put it into a trust, it will avoid, if it's done correctly, the deeds recorded properly and all of that, it will avoid probate. So when Karen passes away, she won't have to do a probate. She'll just, whoever she has as the beneficiary in that trust will automatically get the property. That's same with joint tenants with right of survivorship. I don't know if everyone's familiar with that, but that's another way you can own a piece of property. You can have 2 people on the title, so that when someone dies, if you have 2 people, if John dies, his 50% automatically goes to Sarah. If Sarah dies, her 50% automatically goes to John. And so those are ways to avoid probate. Those are probably the most common ways. The joint tenants with right of survivorship, trusts are becoming more and more common. Those are things that you could probably tell your clients about, but I wouldn't recommend you all do that yourself. I don't know if you guys have in-house title who does that sort of thing, or title attorneys or anything that you work with.
Yeah, we have title.
Yeah. Okay. 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 There you go. Yeah.
I have a question.
Yeah.
When a trust holds ownership or deeded TRS, does the person, the BEN, have to be listed on title as well? Like it shows on that tax
I
roll?
don't think they have to, but they usually are.
But it doesn't disqualify the beneficiary if it's not listed that
No.
way.
I've never seen that issue. I don't know. No, I've never.
By the way, I've told you guys, just in case in some of the contract classes that I've taught, you guys have heard that don't use IMAP for your tax source for you, but don't. It's not. Miami, the Dade County Property Appraisers website is the one that has those little initials, and they will include it. I've seen, now that I'm in management, I'm like, oh my gosh, I can't believe so many people make this mistake. You put on the listing agreement or on the offer who's listed on IMAP, and guess what? You're missing all the codes. You're missing all the codes. Sometimes not even all the property owners are there. So don't use IMAP. Don't use IMAP for your source of finding the property owner. Got it? Don't use IMAP. Okay.
You have a question?
Tenants buy the entirety of the driver's survivorship, doesn't that?
Yeah, that would avoid probate as well. Yeah. And so yeah, so I already said that, but a misconception is wills do not avoid probate. So, so if you have a will and it's done properly, everything's correct on the will, and it says, you know, I leave the property to my son, you can't take that to the county or to the judge or anything and say, okay, now just transfer title. If you have a will, you're going through probate. So that's a huge misconception, and yeah, so just something to be aware of, that if someone says, oh yeah, I don't need to do it because I have a will, unfortunately, you know, if they didn't have the title done correctly, or if they didn't have it put in a trust, it's going to go through probate. Yes, sir.
Let's say I'm a member of my mother's trust, but then my daughter, if I die, my daughter's going to inherit my part of the trust, but she's not in the trust. Do I need to make a second trust for her?
Yeah, you need to make a trust. You need to make your own trust
For all my assets?
for your stuff. Correct. Yeah, correct. Okay, so that's. Let me see if there's anything
So why
else.
is it good to have a last will?
Is it good to have a will?
No, why is it?
Why is it good to have a will? So, that's a good question. I think wills are useful because most people, trusts are more complicated. Trusts, frankly, are more expensive. They're harder to. I don't know if they're harder to change, but they do require a little bit more upkeep. And I think, frankly, just cost is what keeps a lot of people away from doing it. Some mortgages won't allow, if you have a mortgage, you can't put it into a trust, or it has like a due on, it accelerates the loan sometimes. I think wills are good if you, let's say you have, a family heirloom that you really want your daughter to get, okay? And you could put those type of specific things in the will. You could, if you have minor children, you could do a guardianship provision that says, if I were to pass away, I want this person to take care of my children. Or if you have, children that, maybe you don't like one of them, and you want to leave everything to one child instead. It happens a lot. It happens a lot. I get wills all the time. That's not all the time, but fairly common that say, I always use John and Sarah, but I leave everything to Sarah. I specifically do not leave anything to John. It's sad, but kind of funny, but sad. I get those all the time. So, and the thing is, in Florida, the law is pretty clear about who gets what. So if you don't have a will, so if you have no will, first your surviving spouse gets everything, and then your children get everything, and then your parents, and then your brothers and sisters, and then your grandparents. There's a hierarchy of who gets what. So you don't really need a will because the law says who gets it. That's why if you want to do something that's a little bit different, like if you want to leave something to a cousin or a charity, right? So then that makes sense to do a will. But if you have, if you just you and your spouse and you have 2 children and you want everything to go to your spouse and then to your children, do you need to do a will? Probably not. Maybe not. Yeah. All right.
So you said that the hierarchy was your children.
No,
and
no,
then
Children, parents. Yeah. Okay, so I think that's pretty much it on. So those are. So this is like so that's just to give you an idea of. Now you've identified a property that's going to go through probate. So first you just, the easiest way is looking at the tax roll, property appraiser website, just to see if you see any of that. Obviously, if somebody says, hey, my friend's mom just passed away and her children want to sell the property, you can start thinking probate. But this is an easy way to identify if you think it's going to go through probate. So, all right, great. Now you've identified it. Now you're going to go to the listing presentation. And so this I guess course kind of comes at it from the listing side of it. So this is a potential listing that you're going to get, you find on your own. Okay, so that's kind of where we're at. So let's say you find a property, you're getting ready to go over there for listing presentation to speak with this person about selling their property. I always say there's 2 questions, 2.5 questions you want to ask. You want to make sure you're speaking with the right person. And it's very common, sometimes people have maybe a misconception about who's entitled to the property or who can sell the property. So you want to make sure, you want to make sure who the right owner is in this situation. So 2 questions to ask. The first question is what we were just talking about, do they have a will? Did the person who died, did they have a will? And if they did have a will, you know, part 2 is, do you have a copy of it? And so here's the reason you want to ask if they have a will. The will is going to say, usually, who gets the property, okay? And so let's say, you know, you're talking to somebody, and they're the only daughter, you know, she's, you know, yeah, my mom told me I get the property, but in the will it says her cousin gets the property. Well, you don't want to really waste your time speaking with the daughter because the daughter's not going to be able to sell the property, the daughter's not going to get the property. So you want to ask, did they have a will? Then you want to ask, can you, if you have a will, can you get a copy of it, or do you have a copy of it?
Do you think they would provide it?
Well,
No. No.
and if they know what it says and they don't get it, no, they're not going to give it to you. But sometimes people don't understand the wills either. And I've had it. We are doing one recently where he thought it was going one way and it's not going. It's not going his way. So ask if they have a copy of it. And more so, the reason you want to ask is you want to make sure if it's not written down. Generally, it's not enforceable. Okay, so you can't just say, yeah, you know, I was taking care of my brother. He'd been really sick. All of his kids abandoned him. Hasn't seen him in years. I was, you know, managing everything. He told me I get the property. I think he wrote it down, but I'm not sure where it's at. Well, if he doesn't have it, chances are, you know, we're not going to be able to prove that. So ask if there was a will, and then ask if they can get a copy of it. If they have a copy of it, if they can get a copy of it. The second question I would ask is, what's your relationship to the person who passed away? And the reason being, again, what we were just talking about with kind of the hierarchy of who gets what, you know, children, parents, grandparents, and whatnot. You want to make sure, and this is not really your job to identify, you know, you'll bring in your attorney, your probate attorney, to make sure everything is right. But you want to make sure that you're speaking with somebody who probably has a chance of inheriting this. And if you're speaking, and again, very common here in Florida, if you're speaking to a second or third or fourth, you know, long distance cousin, again, chances are they're not going to be inheriting that property because, again, you've got to go through so many different people before you get to the cousin, to the second cousin. And this is all really to protect you all because you don't want to spend all this time, you know, doing all of this, signing these contracts, doing everything, only to find out, wait, they don't get anything to begin with.
Yeah.
Do half siblings has the same right as siblings? Or is
Good question.
That's a very good.
I would say it depends. It depends on if it's from the mother's father's side. It depends on yeah, it depends on who died. It depends, were they adopted officially?
okay, I died. I have one sibling and one half sibling. Do I have the same right if I don't have a will? They're both my siblings. One is a half sibling, the other one is a full sibling.
Again, a lot of questions. It depends how old they are. It